Hi, my name is Jin Siang, and today I'm going to talk about undue influence from the English positions and the Malaysian positions. So let's get started from the English positions. So what is undue influence? In the 2022 case, Samra and others against Kanya actually pointed out that there's no precise definitions of law settings limits to equitability jurisdictions of a court to relief against undue influence. The court held that this is a role of doctrine and not a role of neat and tidy rules. Anyone who has tries to find legal definitions of undue influence is most likely to find that there's no precise definition that is being discovered by the authorities, as the authorities actually make clear that the concept of undue influence is extremely hard to prove. As long as in 1857, Lord Kenworth actually pointed out the difficulty of defining with distinctness what is undue influence. However, in the Royal Bank and Scotland case, the court actually held that undue influence is one of the grounds of relief developed by the courts of equality as a court of consistency, that the objective is to ensure that the influence of one person to the another is not abused. On the other hand, the Malaysian defines undue influence in the Contract Act 1950, Section 16. A contract is said to be induced by undue influence where the relationships between the parties are such that one party is in a position of dominating and will of the other parties and uses the positions to gain unfair advantages over the others. This means that if the party to a contract is in the positions of power of authority over the other party, and they use the positions to pressure the other party to sign into a contract that is not in their best interest, then the contract may be considered to have been induced by undue influence. Now, I'm going to talk about the four elements that's being set out by Lord Hoffman to prove actual undue influence. So, first of all, it is an equitable wrong committed by the domain party against the another. This means that the person who exerted undue influence must have been in positions of power and authority over another person, that they must have used that positions to take advantage of the another person. Secondly, it must be unconscionable for the domain party to enforce its legal rights against another. This means that it will be unfair for the domain party to benefit from the transactions given the consequence in which it was exerted into. There must be some express conduct overbearing the other party wills. This means that the domain party must have been used some form of pressure of concretions to get the other person to sign the contract. Actual undue influence does not depend upon some pre-existing special relationships of influence between two parties. This means that the undue influence can occur in any type of relationship, even if the domain party does not have a traditional positions of power or authority over the other person. It is important to note that the four elements must be met in order for the court to prove that undue influence was exerted. In the case of Rajim against Harvard, a 2023 case shows that the Royal Bank's case is actually still applied today. The elements that's being used in the case is 1. The relationships of trust and confidence and the dependency between the two parties. A transaction has been manifestly disadvantageous to the another person who is influenced. The burden of proof in undue influence case is on the person who is alleging that undue influence was exerted. However, if a person can show that there is a relationship of trust and confidence or ascendancies and dependencies between two parties and the transactions was manifestly disadvantageous to them, the burden shifts from the party to show undue influence was not exerted. This is because the law recognizes that the people who are in the positions of trust and confidence over another person have a duty to act fairly and the best interest of that person. If a person uses the positions to take advantage of the other person, then the law will presume that they have exerted undue influence.
The main issue in this case is whether the contract between Devi and the bank is voidable. Before this, we will have to determine whether the contract signed by Devi was being under influence by her husband Chandran. Under Section 10 of the Contract Act 1950, only when an agreement is made out of free consent can be considered as a contract. In this case, Devi was being convinced by Chandran to put her house out for a loan, which was in a negotiation with his bank. Meanwhile, she was being persuaded by the bank manager, who is also Chandran's friend, to take up the offer made by Chandran. Therefore, there is no free consent given by Devi. There are two elements to be fulfilled for undue influence under Section 16, subsection 1, whether relations subsisting between the parties are such that one party is in a position to dominate the will of the other and uses the position to obtain an unfair advantage over the other. According to Section 16, subsection 2, a person is deemed to be in a position to dominate the will of another where he holds a real or apparent authority over the other, or where he stands in a fiduciary relationship to the other, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by the reason of age, illness, or mental or bodily distress. It was held that in the case of Public Finance Berhad against Lee Rubber Factory Sanjran Berhad and others, the relationship between husband and wife did not give rise to the presumption of undue influence. In this case, Devi and Chandran are both husband and wife. By applying the principle from the above stated case, there is no presumption of undue influence between both of them. If the presumption of undue influence was being established, the burden of proof falls on Chandran. Meanwhile, in this case, Devi was not being mentioned of having any mental incapacity. Therefore, this case might fall under Section 16, subsection 1 as actual undue influence. The first limb to be fulfilled in Section 16, subsection 1 is that whether Chandran was in a position to dominate the will of Devi. The case of Yerkes against Jones shows that the approach of the court is that there is nothing unusual in a wife to showing her affection for her husband in a tangible way, as for example, by guaranteeing repayment of his debt. And so it is said that the affection and confidence inherent in the marital state does not, ipso facto, amount to undue influence in the eyes of law. From the facts shown in the case of Devi and Chandran, it does not amount to any undue influence. To fulfill the second limb, Chandran must have obtained an unfair advantage from Devi. In the case of Swagai Biao against Chong Shu Wen and others, the court rarely overturns a transaction based on undue influence. Courts are unlikely to intervene even though the bargain might be harsh, unless there is an exceptional situation where the manifest disadvantage is obtained. This is to prevent victimization. This principle is applicable to both the gift and business transaction. Other than that, in the case of Ibrahim B. Musa against Bahari B. Nayan, the old lady's estate brought up undue influence to resist Ibrahim's claim regarding specific performance of the sale and purchase of the property. It was held that even assuming Ibrahim was in a position to dominate the will of the old lady, it must be shown that he used that position to obtain an unfair advantage over her. The sale of the property was not undervalued, which there was no unfair advantage. By applying the principle, there is no manifest disadvantage in using Devi's father's inherited house as a security for Chandran's loan. In return of having a share profit of the business, each of them gained an advantage. Meanwhile, before Devi was being persuaded by Chandran to enter into the contract, she was planning to use the house for business purposes. However, Devi might not be aware that she might lose her house if Chandran fails to pay the loan, as she was not being briefed by Chandran's solicitor about the risk of it. In the case of Royal Bank of Scotland against Adryna, it was being explained by the House of Lords that banks are obliged to make sure that their clients obtain an independent legal advice. Devi did not meet up with her own solicitor to get advice. Instead, she met up privately with Chandran's solicitor, who did not manage to explain the risk of using her house as security. In short, the bank failed to make sure whether Devi had an independent legal advice from her own solicitor. As a conclusion, there is no undue influence between Devi and Chandran, but the contract between Devi and the bank is still voidable since Devi did not enter into the contract with free consent and independent legal advice.
Next, we will move on to fraud in Chandran in Malaysian law. So under Section 16, subsection 1, there are two elements in which must be satisfied for undue influence to be proved as stated previously. Addressing the first element, we will refer to Section 16, subsection 2. The first is to determine whether Chandran had any real or apparent authority over Fawad. By referring to the case of Rosli B, Darus, and Mansoor at Harun bin H.J. Sa'ad, the plaintiff was totally dependent on his uncle for daily subsistence due to losing his father at a young age. Then, when the plaintiff reached the age of majority, he then inherited his deceased adoptive mother's land, in which he then conveyed to his uncle and another uncle. The plaintiff then wanted to set aside the conveyance on the basis of undue influence, due to the fact that his uncle had real and apparent authority over the plaintiff. A position of domination could be presumed. In the case of Kao Cheng Bok and others and Kao Cheng Poon and others, family members alleged that the deceased father was unduly influenced by his third son and gave the third son and his family gifts. The third son was the only son living with the deceased father, making him totally dependent on the son. He was also the deceased father's favorite son. The court held that the gifts given were very large and thus could not be reasonably accounted for on the grounds of their biological relationship, and that the transactions could not have occurred otherwise if there was no domination of the will of the deceased and the family had not used any of their position to obtain an unfair advantage. Applying to the current case, the relationship between the parties is friends. Fowd often sought investment advice from Chandran because he felt Chandran was well versed in business affairs. However, it does not seem that Chandran had any real or apparent authority over Fowd. In the case of Rossley, the defendant had real and apparent authority over the plaintiff because the plaintiff was dependent for daily subsistence. In the case of Kao Cheng Bok, the deceased was totally dependent on his third son as he lived with them. In this case, Fowd and Chandran are merely friends, in which Fowd is not dependent on because Chandran has no control over him. Therefore, it can be stated that Chandran had no real or apparent authority over Fowd. Therefore, moving on, one party must have been a fiduciary of another. As per Millett LJ in Bristol and West Building Society and Matthew, a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. A fiduciary must act in good faith, he must not make a profit out of his trust, he must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or the benefit of a third party without the informed consent of his principal. In a journal article titled Undue Influence, Unconscionability and Good Faith, written by Hans Zhou, it states that a fiduciary is prescribed from allowing his interest and duty to conflict, nor can he make a secret profit. He is duty-bound to subject his own self-interest to the beneficiary. A person should only be classified as a fiduciary when he or she is under such intense scrutiny. Applying to the case at hand, as Chandran often gives Fowd investment advice, it can be said that Fowd is someone who has undertaken to act on behalf of Chandran in a particular matter, as Fowd will be acting upon Chandran's advice. Next is whether it gives rise to a relationship of trust and confidence. Fowd feels that Chandran is well versed in business affairs, which is why he asks Chandran for investment advice. This shows that Chandran has some degree of influence on Fowd because Fowd is willing to listen to Chandran's investment advice. Although the case doesn't mention explicitly whether Fowd follows all the advice that Chandran gives him, it seems that Fowd has some level of trust on Chandran because he believes that Chandran has some expertise or special knowledge that he does not have. Thus, it seems to suggest that there is some relationship of trust and confidence. However, in the case of Public Finance Berhad and Lee B Rubber Factory, it states certain classes or relationships that by themselves give rise to a presumption of influence, such as parent and child, person in loco parentis and his charge, a guardian and ward, a doctor and patient, a solicitor and client, a spiritual advisor and a member of his congregation, a man and his fiancée, and a trust and beneficiary. Fowd and Chandran do not fall under any of these categories. Furthermore, it states that a fiduciary must act in good faith and must not make a profit out of his trust. This clearly does not apply to Fowd because he is asking for investment advice. The sole purpose of asking for investment advice is to make good investments and in turn make profits. Fowd is clearly making a profit from Chandran's advice and thus is not considered a fiduciary. There is no mention that Fowd has any mental illness. Thus, no presumption of undue influence is established. On the facts, there is also no unfair advantage to Chandran of the security contract, as Fawad is promised to get a share in the profits of Chandran's business. The transaction must also be unconscionable on the face of it or through evidence adduced. In the case of Raghunath Prasad and Saju Prasad, the transaction was unconscionable because of the high interest rates charged. In this case, Fawad charged his shares to the bank, and in return, he would receive a share in the profits of Chandran's business. Nothing in this transaction appears to be unconscionable. In conclusion, undue influence is not established, and Fawad cannot avoid the security contract.
Now, we are going to look at both the cases under English law. First, let's start with Devi's case. The contract between Devi and the bank involved a potential issue of undue influence. Under English law, undue influence cases can be identified as two types. One is actual undue influence, another is presumed undue influence. Presumed undue influence cases can be further divided into Class 2A undue influence and Class 2B undue influence. Class 2A undue influence cases require special relationships such as parent and child, trustee and beneficiary, solicitor and client, and so on. While Class 2B undue influence cases require no special relationship, but the innocent party must show a past history or one party place trust and confidence on another party to raise a presumption of undue influence. There are two steps needed to raise a rebuttable presumption of undue influence. First, the innocent party must show either a special relationship or a past history on trust and confidence, usually on financial matter, between the two parties. Midland Bank against Shawherd shows that the relationship of husband and wife cannot be considered as a special relationship. Thus, the relationship of Devi and Chandran does not raise a presumption within Class 2A. However, basic trust and confidence is presumed to exist between the spouses, so this case will fall within Class 2B. As the relationship is proven, it raises the presumption of undue influence in respect of the transactions to be avoided. Second, there must be something about the transaction which calls for an explanation by the dominant party. To address this issue, we can use the approach used in Royal Bank of Scotland against Adryna No. 2, which focused on the nature of transaction rather than the disadvantage in the transactions. Bigwood had confirmed the use of this test in his article, stating that the House retreat from the manifest disadvantage test in Adryna is thus most welcome. He mentioned that the approach discarded manifest disadvantage as a necessary ingredient of presumed undue influence, in contrast with the previous test in CIBC Mortgage plc against Pitt, which require manifest disadvantages as a necessary ingredient to raise presumption. However, according to Lord Nicholas, disadvantage can still be a relevant matter in establishing a presumption of undue influence. This differs with the Malaysian law, as it is a must to show an unfair advantage in Malaysian undue influence case. Applying the test in the scenario, Devi used the large house left by her father as a security for loan, and Chandran promised to give her a share in the profits of his business. Although there is no manifest disadvantage in the transaction, it was sought to have some inexplicability in its nature. The large house had sentimental value and it was irreplaceable for Devi. If Chandran failed to pay the loan, Devi might lose the house. Furthermore, Scott in his article stated that the new test is not inherently limited to financially disadvantageous transactions, which means that non-financial factors may be taken into account when assessing a transaction. When evaluating the inexplicability of the transaction, the woman's sentimental attachment to the house would be taken into consideration, even if it is not a financial matter. Devi might not have used the house as security for a loan if the pressure hadn't applied to her, as it would be too great a sacrifice to use her valuable inheritance for Chandran business. The transaction since that cannot be explained by ordinary motive. Thus, a rebuttable presumption of undue influence arises, and the burden then shifts to Chandran to provide further explanation. Following Pitt, if undue influence is exerted by a third party, the contract is voidable, but only if the third party was acting as another party agent of the other party had knowledge or contracting motive of the undue influence. For the first point, it cannot be proved, since Chandran is not acting on behalf of the bank. For the second point, obviously, the bank had not actual knowledge of the undue influence. However, it did have contractive notice, as the bank manager advised Devi to see her own solicitor before signing anything. This makes the contract voidable, shifting the burden to the bank to provide an explanation to rebut the presumption. Another issue that needs to be considered is whether Devi entered the contract under free will. Traitor mentioned that The parties benefiting from the transaction need to show that the transaction was a free exercise of the independent will to rebut the presumption. Providing independent legal advice is the most common way to demonstrate independent will, but it may not always rebut the presumption. In R against Adryna of England and Wales, although the soldiers signed a contract without independent advice, it was held not to be an unfair exploitation. In O'Brien and Ethics, more detailed guidelines are provided to be followed by the bank when dealing with the sureties. Failure to follow the guidelines could mean that the bank has contracted notice of the third party undue influence. First, banks have put on inquiry in every case where the relationship between the surety and the debtor is non-commercial. In this case, Devi and Chandra are husband and wife. The relationship between them is non-commercial. Next, the creditor will normally be regarded as having taken reasonable steps by warning the surety not in presence of the principal debtor of the amount of the surety potential liability and risk involved, and advising them to take independent legal advice. In this case, it is unsure whether the bank manager warned Devi without the presence of Chandran as they visited the bank together. But the manager did advise Devi to take independent advice. Devi's further meeting with the solicitor was private, which means Chandran was not presented at the meeting. Also, Devi seeing Chandra's solicitor is regarded as fine since the debtor and surety can use the same solicitor. Last, there must be a face-to-face meeting between the solicitor and the surety. The solicitor should explain the transaction and its implication in suitably non-technical language. Regarding to this guideline, the main problem now is that the solicitor had failed to explain the risk involved in using her house as security to Devi. Therefore, it can be said that the bank has failed to take reasonable steps to ensure the surety enter into the obligation freely and with knowledge of the true facts. Thus, it has contracted notice of the third party undue influence. The presumption cannot be rebutted, and Devi can set aside the contract. Parties are restored into their original position. However, the loan agreement between Chandran and the bank is still valid, which means that if Chandran cannot repay the loan, he will still be sued. Chandran can argue that Devi also had intention to do some sort of business. Therefore, she might not have been fully influenced by him to enter the contract. However, according to the approach in UCB Corporate Service Limited and Billions, Devi did not need to prove that undue influence exerted by Chandran was the sole reason she entered the contract. It can just be one course of action. Thus, Devi can avoid the security contract by establishing undue influence exerted by Chandran. Moving on to the security contract between Feld and the bank. The issue here is whether Feld can avoid the contract, and we'll have to look at whether he entered the contract with the bank due to the undue influence exerted by Chandran. First, we need to prove either a relationship or a pre-existing relationship of trust and confidence between Feld and Chandran. The relationship cannot fall under any category of Class 2A. Regarding the passage, they are long-time friends, and over the years, Ford has sought environment advice from Chandran, and he felt that Chandrans are well versed in business affairs. From the first, it was shown that he was confident in Feld's expertise. Plus, the investment in a business affair can be considered as a financial matter. This fact showed that Feld had placed trust and confidence in financial matters in Chandran in the past, which gives rise to the presumption of influence with respect to the transaction in question. Next, we need to examine that whether there is something in the transaction which calls for an explanation by the dominant party. Similar to Devi's case, Chandran also promised Ford a share of his profits in his business if he used his share in a public company as a security of a loan. However, unlike Devi, who used his inheritance from her father as a security of loan, using shares in a public company as a security for a loan is a normal business practice. Thus, there might not be things that need to be called for explanation in Feld's case. Feld cannot raise the presumption of undue influence and the contract cannot be avoided.
In conclusion, Devi has a legal basis to avoid contract with the banks in both Malaysia and England. However, Ford does not have a legal basis to avoid his contract with the banks in either country.